Trump gets temporary reprieve from losing control of companies in New York. New York, a New York State appellate judge Friday temporarily blocked the revocation of the Trump Organization's state business certificates ordered last week when a trial judge found Donald Trump and his company liable for fraud. Associate Justice Peter H. Moulton's ruling calls for at least a temporary pause in the start of a receivership process and the dissolution of the Trump Organization and related entities ordered in a September 26 summary judgment decision by New York Supreme Court Justice Arthur Engoron. Moulton denied Trump's emergency request to halt his ongoing civil trial on other fraud claims. Trump lawyer Christopher Kise argued at an emergency hearing at the New York Supreme Court Appellate Division's First Department that several entities not named in the lawsuit were ordered dissolved and that it was unconstitutional. He also said irreparable harm would be done to significant parts of his client's hospitality, golf resort and real estate businesses if the state shuttered Trump's entities. "We are very pleased the First Department upheld New York law and put a halt to any cancellation of business certificates, receivers or dissolution," Kise said in a statement after the court arguments. The trial court's attempt to reach issues, entities and assets beyond the scope of this case has been suspended. New York Attorney General Letitia James, Democrat, said in a statement released after court arguments that her office proposed working with the defense to allow more time for compliance with the Engoron order without the need for an appellate court ruling. "Unsurprisingly, Trump is twisting this ruling and falsely claiming victory for a resolution we proposed," James said. Moulton's ruling puts on hold the cancellation of licensing that gives Trump authority to conduct business in New York. Arguments on the merits of those and other restrictions on Trump's businesses imposed by Engoron will be filed in the coming weeks and evaluated by a full panel. Under Engoron's order, a collection of Trump entities are expected to be taken over by a court-appointed receiver and dissolved. Under Friday's appellate order, the parties must still submit receivership recommendations, which will begin the dissolution process. Engoron's decision to shut down Trump entities means Trump's New York properties, including Trump Tower on Fifth Avenue, may ultimately be sold by the receiver. James sued Trump and other defendants last year for $250 million and for further restrictions on the Trump Organization's ability to operate in the state. The first week of the trial in James's case against Trump, current and former executives, and the company ended Friday. The former president, a Republican candidate for president in 2024, attended the proceedings for 3 days in a row, holding news conferences in the hallways and claiming he has been unjustly treated. The trial is expected to determine whether there was intent to commit several crimes by Trump and others while they allegedly engaged in a long-running scheme to deceive lenders and insurance companies. James has argued that Trump, the company and other company operatives committed crimes to obtain better rates in business transactions. James's office said in court Friday that it was open to discussing a postponement of the takeover that Engoron ordered, but did not believe the defense would ultimately prevail on getting the restrictions overturned. The trial will continue as scheduled next week. Dozens of witnesses, including Trump, are expected to testify during the trial. Trump seeks dismissal of D.C. case, saying he's immune to prosecution. Lawyers for former President Donald Trump urged a federal judge Thursday to toss out the indictment against him for allegedly conspiring to block the results of the 2020 election, arguing that as president at the time, he was acting within the legal boundaries at the heart of our system of government. Trump lawyers John Lauro and Todd Blanche, in a 46-page filing, argue that Trump is immune to prosecution for the acts cited in the indictment filed by special counsel Jack Smith, a legal claim they have been making since the indictment was filed in August. As the Constitution, the Supreme Court, and hundreds of years of history and tradition all make clear, the president's motivations are not for the prosecution or this court to decide. Rather, where, as here, the president's actions are within the ambit of his office, he is absolutely immune from prosecution, the filing argues. Trump denies the charges leveled in the indictment, that he conspired to obstruct Joe Biden's 2020 victory in the presidential election, and also conspired against Americans' right to vote and have those votes counted. The defense argument for dismissal, however, is not about whether Trump did what prosecutors accuse him of doing, but rather whether he is immune from prosecution because he was president at the time. In the filing, Trump's attorneys detail some of the same post-election interactions that prosecutors note in the indictment, including meetings and communications with Justice Department officials. But in their telling, if Trump participated in these meetings, he was acting within the bounds of his presidency, not committing crimes as prosecutors allege. In their motion, the lawyers argue that the courts have long shielded U.S. presidents from lawsuits over actions taken while they were serving in that position, and say the same principle should extend to criminal prosecutions. The lawyers add, however, that the Supreme Court has not weighed in on this issue of whether or when a president is immune to criminal charges, suggesting it could be a legal debate taken up not just by the trial judge, Tanya Chutkan, but an appeals court or the highest court in the land. No court has addressed whether such presidential immunity includes immunity from criminal prosecution for the president's official act, the lawyers wrote. They argued that the proper venue to decide the guilt or innocence of a president is impeachment in the Congress. Trump was impeached by the House of Representatives for actions surrounding January 6 but ultimately acquitted by the Senate. The Justice Department's four-count indictment charges that Trump's actions after he lost the 2020 election amounted to a criminal conspiracy to remain in power. It is one of 4 felony prosecutions Trump is facing, including a state trial in Georgia that involves similar allegations of trying to obstruct the election results in that state, a federal indictment in Florida over Trump's alleged hoarding of classified documents after leaving the White House and obstruction of government efforts to retrieve the information, and a state-level case in New York in which Trump is accused of falsifying business records in connection with a hush money payment made during the 2016 election campaign. Trump's lawyers in the New York case also filed a dismissal motion Thursday. Blanche, who is representing Trump in both cases, and attorney Susan Necheles argued the case, brought by Manhattan District Attorney Alvin Bragg, was an unjust effort that relied on novel legal theories and a problematic witness. The probe began in 2019 and did not yield an indictment until March, which Blanche and Necheles said constitutes a violation of Trump's due process rights. In the D.C. motion to dismiss, Blanche and Lauro wrote that alleging the president acted illegally does not necessarily mean that he acted beyond the outer perimeter of his job, citing a Supreme Court case from the Nixon era. They argued that if Trump was not immune to prosecution for his actions, a president theoretically could be subjected to a trial every time someone alleged he was acting illegally. Any decision by Chutkan is likely to come after a counter-argument from prosecutors, and possibly a hearing on the matter. Legal experts have said that the issue of presidential immunity is one that the higher courts may take up before Trump goes on trial, a rare exception to general court practice, which says most appeals issues must wait until after a verdict. Trump's attorney suggested that they may file additional pretrial motions in coming days. Chutkan has said all such motions must be filed by Monday evening. Other fatal deficiencies in the indictment will be addressed in future motions and proceedings, the filing states. Shayna Jacobs in New York contributed to this report. Judge issues gag order in fraud case after Trump assails staffer on social media. New York, the judge overseeing a civil trial over alleged business fraud committed by Donald Trump and his company issued a gag order in the case Tuesday, barring the former president from making public comments about his court staff. The decision by Judge Arthur Engoron, announced about a day and a half into the trial, came soon after Trump posted on social media about a staffer for the judge and included a picture of the person. Trump had already spent a significant amount of his time outside the courtroom lambasting officials in the case, repeatedly pillorying Engoron and New York Attorney General Letitia James, Democrat, who brought the lawsuit. Engoron's decision amounted to a sharp rebuke of at least some of Trump's commentary. The gag order applies to all parties involved in the case, though it appeared aimed primarily at Trump. Speaking in court Tuesday afternoon, Engoron said he had issued a warning about such posts a day earlier. He addressed Trump's behavior by saying one of the defendants had shared a personally identifying post about one of his staff members. Engoron publicly announced his decision following multiple closed-door sessions with Trump and his lawyers as well as James and attorneys with her office. The judge said he had ordered the post deleted, and it appeared to be removed from Trump's Truth Social site by Tuesday afternoon. Engoron also warned that violating the gag order would lead to serious sanctions. During the midday closed-door meetings involving the judge, Trump's campaign sent out an email focused on Engoron that sought to portray him as biased, calling him a far-left Democrat judge. Trump's public response to the fraud lawsuit has continued his long-standing practice of responding to investigations and scrutiny by denigrating officials involved and castigating them by name, often in caustic, inflammatory, and bitterly personal terms. In this case, Trump has angrily called James a crook and Engoron a disgrace who should be disbarred. Trump is facing 4 separate criminal cases, and he has called Jack Smith, the special counsel overseeing 2 of them, a psycho who looks like a crackhead. This behavior is not new. During his first presidential campaign, Trump attacked by name a judge overseeing 2 lawsuits against him and then regularly criticized law enforcement officials while in office. Trump's reaction to the New York case has echoed the way he responded to the 4 indictments brought against him, as he has denied any wrongdoing in the cases and dismissed all allegations as politically driven. He has also consistently singled out individuals for criticism while relying on increasingly menacing rhetoric in his public commentary. Trump's tendency to comment on these cases in this manner has triggered a request for a gag order in one of them. U.S. District Judge Tanya S. Chutkan, who is overseeing a federal case accusing Trump of wrongdoing in connection with his efforts to overturn the 2020 election, is weighing a request for a gag order brought by attorneys for Smith. Attorneys for Trump have previously told Chutkan that he is a presidential candidate who has a right to respond to criticism and his rivals on the campaign trail. In the New York case, the gag order came on what was otherwise a fairly routine day of legal testimony from an accountant, with Trump looking on in person for a second day in a row. James has alleged in a $250 million lawsuit that Trump and executives with his company brashly misstated facts about his properties to get better financial benefits. Trump's side, in turn, said there was no one way to evaluate the worth of assets, insisting that there was no wrongdoing. Engoron last week issued a pre-trial decision ordering that Trump be stripped of his business licenses, which could wrest from his control dozens of properties, among them Trump Tower. The trial will determine how severe the ultimate penalties might be, with James asking that Trump and his company pay $250 million. The trial could last for weeks or months, and Trump may testify during the proceedings. While he was not required to attend the trial's opening days, Trump opted to appear in court and, on Monday, used the occasion to speak extensively to reporters before the hearing, afterward and during a break. He issued a fusillade of familiar grievances against the case as well as James, Engoron, and other officials investigating him. Trump, who is seeking the Republican nomination for president, also complained that the case was keeping him off the campaign trail. He returned to the courthouse Tuesday and repeated some of the same points he had made the day before, criticizing James and insisting that his properties were worth more than she had said. But while Trump repeatedly inveighed against the New York case outside the courtroom, the proceedings inside largely focused more on matters at issue in the lawsuit, the nuts and bolts of real estate valuations and how financial statements are created. On Monday afternoon and across much of Tuesday, the proceedings largely centered on testimony from Donald Bender, a longtime accountant for Trump's company and its executives. James's office has said it intends to prove that Trump, his adult sons, his company, some executives, and related organizations sought to issue false financial statements and commit fraud. Trump's attorneys have pushed back on those arguments, with Christopher Kise saying on Monday, there was no illegality. There was no fraud. There are no victims. When Monday's hearing wound down, Engoron appeared to suggest that he was open to excluding evidence related to older transactions, which Trump's attorneys had argued should be dismissed from the case based on a recent appellate court ruling dealing with statutes of limitations. Trump took Engoron's comments as a victory, saying to reporters immediately after that much of the Attorney General's case might be dismissed, which one of his attorneys echoed. James's office later challenged that interpretation. On Tuesday morning, before testimony resumed, Engoron began the proceedings by saying he wanted to clear up any misconceptions that might have arisen over his remarks, and added that he would not be dismissing claims in the case, as Trump had suggested could happen. Soon after, Bender resumed his testimony, discussing things such as the agreements between his accounting firm and Trump's business. While questioned by James's office, Bender confirmed that the agreements would put the burden of providing accurate asset valuations on the company, not the accounting firm. When an attorney for Trump questioned Bender, though, they were critical of his accounting work and suggested that any misreported numbers were his fault. The attorney, Jesus Suarez, questioned Bender about the drastic misrepresentation of a Trump Tower apartment that had been reported as about triple its actual size, inflating its worth. "You're preparing statements of financial condition for the leader of the free world and you missed it? You never picked up the phone and said, 'I'm sorry?'" Suarez asked. Bender said the alternating values for the Manhattan home were an oversight. After Bender's testimony concluded for the day, the parties held another private meeting with the judge. A court spokesman said the private meetings at the lunch break and after court concluded for the day amount to non-public conferences that typically happen in a judge's chambers in civil matters. It was not clear why the issues were not discussed in open court. Leaving court Tuesday when the proceedings concluded, Trump did not address the gag order and told reporters he planned to be back the following day. Berman reported from Washington.